Welcome to Disambiguation. I'm your host, Michael Fawcett. Each week, we interview experts in artificial intelligence, generative AI, and business automation to help business leaders understand how to use these tools for the biggest business impact. On our show today, we discuss when machines create, an IP attorney's perspective on AI innovation. I'm joined by James Gourley, idea and brand protection attorney and partner at Carstens and Gourley LLP. James, welcome.
Oh, thanks for having me.
So just to get started, can you give us an introduction? Tell us a little bit about what you do and what you're working on.
Yeah. I'm an intellectual property attorney, so like patents, trademarks, copyrights. We do my little law firm is about 14 attorneys, all IP attorneys, and it's an IP boutique. So that's all we do is patents, trademarks, copyrights, trade secrets. And we help people file patent applications, file trademark applications, prosecute them, register their copyrights. We also, whenever there are any disputes involving intellectual property, we also get involved in those. I personally am more involved on like the defense side. So a big part of my practice is defending people who are accused of infringing intellectual property. I have been on the plaintiff side a few times, but it just seems like over the last 20 years, kind of more frequently, I'm on the defense side. And that's a part of my practice that I probably enjoy the most.
Okay. No, that makes sense. Well, so this is a bit of a follow-up episode too. I should flag for the audience. We did an episode last season about authors and IP protection and some of the concerns that creators, authors particularly, have had. So I thought it'd be really interesting to dig into the opposite into that and really look at this from a legal framework perspective. And what you're seeing and kind of how that's moved forward. So
Yeah.
maybe to start, it'd be good if you could just give us an overview of how the U.S. Patent and Trademark Office's current leadership is approaching AI-related inventions, and is it different from past administrations? And then, what policy shifts are you seeing?
Yeah. So current leadership, and I know people probably don't want to hear this, but the way the patent office operates is influenced quite a bit by the attitude of the leadership. I mean, we've had, patent office directors in the past that are pretty widely perceived and rightly so as sort of like anti-patent. There have been people that have led the office that were formerly at like kind of large tech companies that don't really favor patent protection for software, for example, because they just kind of want to go do whatever they want to do and innovate and not be constrained by whatever software patents some smaller company has. They just kind of want to go do their thing. So that's kind of in the past, but current leadership is actually more ideologically kind of in favor of software and AI related patents. So they've issued some guidance recently that is sort of instructing the patent examiners to take a little bit different view than maybe they have in the past on software related patents and AI related patents. So the trend right now is in the direction of protecting software related and AI related inventions by patents.
Hmm. Well, so I know when you talk about AI, I know there's a distinction, or at least I've heard this discussed between AI generated and AI enabled inventions.
Mhm.
Can you explain that difference and why it matters from a patent perspective?
Yeah. So on the patent side, they're in order to get a patent, you have to identify a human inventor.
Mhm.
Um, but like I said, there's a another more subtle kind of policy shift with current leadership is um, to treat AI usually in most cases like the same way like a chemist would treat a piece of lab equipment or something like that. So it's something that's there to help them invent rather than just the AI coming up with the invention itself.
Mhm.
And that's that's the instruction that's come down from leadership to the patent
Mm,
examining core, is to look at it from that lens rather than, oh,
mm.
it was just the AI that did this. It's like, no, it's more analogous to a piece of lab equipment that a research chemist used to come up with something.
Yeah, I mean that makes a lot of sense to me as an author and a creator that that I'm using this to enable what I do and make me more productive and effective and that sort of thing because it's a great research tool and sometimes as an author it certainly does help you with that blank page problem that you have sometimes when you're staring for hours going, how do I start this thing? So
Yeah,
that makes sense.
yeah. So you're kind of like that. That comment is more towards the copyright side, which is very different right now.
Mm,
Um, right now, uh, AI generated content is really not protectable by copyright. I think the scenario that you laid out, where it just helps you with the blank page and kind of gives you some ideas to get started, but where the final product is really your own work,
mm,
that's still protectable by copyright. But if you just put a prompt into like a GPT and it spits out an image,
mm,
that image is not protectable by copyright
mm.
today. So um,
Interesting.
yeah.
Hmm. Interesting. Well, that kind of brings me to another point too, because we've read a lot over the last couple of years about copyright lawsuits, like the New York Times and others
Hmm.
against AI companies about how they trained their model on
Hmm.
copyrighted content. And I know, authors that I talk to, some of them have expressed, concerns about that. I mean, what do you think about those cases? And, do you philosophically, how do you think about this training and what, the models are allowed to train on?
Yeah, I mean, from a philosophical standpoint, my personal opinion is that the AI companies should be able to train models on it, because I can analogize it to basically a human reading something and synthesizing it in
Mm,
their own brain and kind of using it to inform the human's world model. And I think that's basically what the AI models are doing.
mm,
Now, it's a little more subtle in that, like the New York Times, for example, like the New York Times sued, I think OpenAI, and that's kind of a big deal.
yep,
What the New York Times was able to do was go into ChatGPT and actually get it to reproduce articles verbatim,
mhm,
and that's a really smart human might be able to do that to some extent, if they just kind of have like a photographic memory.
right,
Um, but a lot of humans can't do that. If you read a New York Times article and somebody comes along, several months later and says, "Hey, can you reproduce that article that you read?" A human can't really do
mm,
that.
nope,
Now, what's not really clear is how much coaxing it took for the New
mm,
York Times to really get the model to reproduce that verbatim. Like that wasn't really clear from the complaint. But
yeah,
I guess maybe they spent enough time with it where they were able to get it to spit out at least portions of New York Times articles verbatim, and that's a little bit different.
yeah,
But that doesn't that doesn't relate to the training piece. Like, that's the output.
yeah,
If AI output is infringing somebody's copyright, then that's a different situation than just the training piece. So I
right,
think it is incumbent on the AI companies to take steps to prevent just blatant, copying of copyrighted works on their
yeah,
output.
yeah. I mean, in a way, it does sort of remind me of how a person would think about this, right? I mean, I read things, do research, study all the time, and I don't have a photographic memory, so I'm not going to reproduce the article exactly. But I do have access to those New York Times articles because I'm a subscriber, or Washington Post, or whatever. So it sort of makes sense to me that it is almost like that. Like I wouldn't reproduce that content. I mean, that's plagiarism, but I could use anything I learned as a part of my research when I
Right.
write something new, right? And that,
Right.
to me, that does make a lot of sense. So,
Yeah. Yeah. I mean, I even did. I did a little experiment with one of the image generation tools. I told it that I came up with a new video game and I'm looking for some cover art for the video game. And the video game has to do with a plumber who um, lives in a world with like turtles and little mushroom characters and goes in and out of pipes and stuff like that. So I was basically describing
Mm,
Super Mario Brothers, but not using the name.
mm,
And I asked it to generate some cover art, and it was dead on Super Mario Brothers.
interesting.
So I don't. It's a really tough problem for them
Yeah.
to solve.
Yeah. I mean, I understand that, it was interesting. Yesterday, I was listening to an interview with Reid Hoffman, and he told this story that I thought was kind of appropriate and interesting for this and conceptually from how creators could think about this. And he said that a couple years ago, because he's a big proponent of AI, which probably doesn't surprise anybody. He's a big investor in AI. And he said he was talking to a well-known artist, very successful musician, and that musician had expressed concern over the AI stealing their work, and he said, what if you think about it this way, it if I go in and I talk to an engine, ChatGPT or Claude or whatever, and I ask it to write a song in the style of somebody, that's not exactly stealing your work, but it is mimicking in some ways, and you can do that with art too, I guess. But he
Hmm.
goes, if you're an artist and you take that and you used a AI engine to make your work better, to improve your work, then that actually could be a real opportunity for you because you can actually create things that are even better than what you would have been doing on their own. And this, I guess the short story is that artist thought about it for a bit and then they came back later and was like, that actually could be a really valuable asset for me as an artist to be able to iterate on my own work and help me produce something that's even more effective. So I guess it sort of depends on your attitude about how you approach this, right?
Yeah, like I said, I still think you need to prevent exact copies as outputs. I
Yeah,
mean that's kind of like the baseline.
makes
But
sense.
the whole point of art and everything like that is to gather inspiration from others and riff on it and kind of give it
Yeah,
your own spin. And I think you should be able to use AI to do that,
yeah,
you know? And I because any human being, if you're a painter and you study sort of like, any classical artists and you
mhm,
want to make a painting in that style, if you're skilled enough to do that, you're allowed to do that. I mean,
right,
that's the whole thing, but
right,
it's through your own frame and your own kind of interpretation. And I think if you just because you're using an AI tool to do that, I don't think that changes the analysis at all. It's not
right,
saying like, recreate this artist's work exactly. It's like I have this other idea, but I want to do it kind of in the style of somebody else. And
right,
I think that should be allowed. Like
yeah.
that's advancing the ball, you know?
Yeah. Yeah, I mean, that makes a lot of sense to me, and I wonder when you talk about fair use, from that perspective, where's the line? I mean, is it, you mentioned this idea of, okay, I learned something from a New York Times article. Um, is that different than the model ingesting it? I mean,
Mhm.
it doesn't seem that different.
Yeah. You know, there are four factors to consider whenever you're looking at fair use. And one of the biggies is if the use that you are putting the copyrighted work to is what they call transformative. And that's a factor that I think the on the training side that the AI companies have an excellent argument that what they're doing is transformative because they're using it to do something that
Mhm.
the New York Times is not doing. They're training an AI model. New York Times is not doing that. So I think that's like one of the biggest hooks they have for a great fair use argument is that they're taking something and they're completely transforming it into a computer model that can do things that the New York Times cannot do.
Mhm. I mean, it seems to me in some ways that the simple question of do I have access to your work legally or not is maybe one of the base questions, right? If I, if
Right.
I'm
Yeah.
if I'm licensing from you all that content and I ingest it and train on it, I mean we have an agreement, so it's not a problem. But I guess I could understand if I produce a report that I'm going to sell and somebody gets access and uploads it and trains on it without me being able to monetize. I mean that's a threat. That does make sense.
Right. But again, I mean, fair use is a defense to infringement. You know,
Mhm.
if you are able to show a court that you are entitled to the fair use defense and you're under
Mhm.
those four factors, um,
Yeah,
then you don't have to pay. I mean, that's just the way it is, you know?
yeah, yeah. Yeah, I mean that's and I guess as a creator and from a creator's perspective, I mean, what do they need to know about both like how this impacts artwork or inventions or novels or whatever, but also maybe what do they need to disclose? Like when I published a book last year, I put in there, oh, the cover art was created by XYZ model or whatever, because I
Yeah.
felt like I didn't actually check to see if I had to do that, but it made sense to me to say, and I often do that in blog posts, like, "Oh, this chart was created by Gemini Pro or Nano Banana." I actually just like the name Nano Banana Pro or whatever,
Yeah.
right? I mean, to me
Yeah.
that seems reasonable, but from a legal perspective, what should I know about that?
Yeah, that's I mean, I think disclosure is an excellent idea, whenever you use AI to create anything. The other thing though, too, is if you have sort of like a hybrid work where, like you said, maybe you write the book, but you use AI to make the cover,
Mhm,
um, and you ever want to go register the copyright in your book, you need to disclose to the U.S. Copyright Office in your application
mhm,
any aspects of it that were created by AI. Because, like I said, you cannot claim copyright on the AI generated portion.
mm,
And there's a section on the copyright application, copyright registration application, where you identify any portions of your work where you're not claiming copyright,
mhm,
and there is the place to identify the AI generated work.
mm,
Because if you just get a straight up like copyright registration where you don't identify that, it could be invalidated later, and then you couldn't
mm.
protect your copyright in the other aspects that you did create.
Okay. So from a legal perspective, I need to be able to differentiate between something that was created by the engine versus created in my brain.
Yep.
Okay. That again, I mean that's very good to know from a creator perspective. When we were setting this up, we talked a little bit about this, and I'm really curious about how you're approaching this. I know you're working on an on-premises AI solution for legal work. Can
Hmm.
can you talk about confidentiality concerns and that make that necessary, and how are lawyers balancing AI capabilities with this attorney-client privilege?
Yeah, I mean, lawyers are definitely a very special case because we are duty bound to maintain all of the client information that we receive as confidential.
Mm,
And, a lot of these public AI models like Gemini and ChatGPT, they have an option that you can check
yeah.
that where they won't use your questions or answers to train their models. Um, and to some lawyers, that's good enough.
Mm,
Others don't think that that's adequate enough protection because they're kind of like all on the same server and you never really know what's going on behind the
mm,
scenes and everything like that. So there are um, kind of AI startup companies that are addressing the legal world specifically and will do things like just have cloud containers that are
mm,
self-contained that don't go anywhere, and they certify that that's happening, that your information is not really being commingled anywhere else.
mm,
So that's kind of the cloud version of that. But then others are taking it even another step further and saying, "Hey, we're going to have a server at our law firm running this model locally, and it's literally not leaving the confines of our office to go anywhere." So
yeah.
that's kind of the more extreme case. So it's still, it's so new. There's no
Mm,
sort of one solution that everybody's settled on. It's kind of a case by case, whatever you think your client's risk tolerance is,
right.
with that kind of thing. So still very
Mm.
much in flux, and everybody's trying to figure out where they're going to land.
Yeah. I mean, as a technology analyst, a lot of my clients are large, software companies, and I get briefings regularly that are, covered under NDA for some period of time. And they'll share the decks with me. And I thought about this and I built this a couple of years ago, actually. I run a local open source LLM with a client, chat client on my local computer, and I only allow it to connect to the internet when I'm asking a question that it needs to retrieve a specific, right? So it doesn't there's no way it leaks that information. And maybe that's overkill, but it just made me feel more confident that I was actually meeting the spirit of that NDA by approaching it in that very controlled way. So
Yeah,
it's similar, right?
yeah, absolutely. I mean, if you've got, if you've got something that's, not just secret, but like super secret, highly valuable,
Yeah.
I don't think that's overkill at all. Because you know, it, I don't think anybody has had a dispute like this with any of the, open AIs of the world where they've really gotten a look at the back end, see, okay, how is this really being handled? Even if I have that box checked where you're not
Right.
using it to train the model, like, is it really safe there, or is it, is there an opportunity for it to leak out into other parts of the organization?
Right. Yeah, I mean, to me, that seems like a risk, and so I think it seemed be better safe than sorry, I guess, is the
Yeah,
way
absolutely.
to think about that in my mind, right?
Hmm.
Well, you mentioned the administration, and I know those of us in the tech world have known David Sachs for a long time, right? I mean, did a lot of work with Yammer when he was when he founded that, and now he's there, as the AI czar, I guess. How much influence do you think, he has and other figures in the administration? And are we seeing, more kind of a libertarian approach to AI regulation and IP enforcement under the current administration?
Yeah, absolutely. I think David has a lot of influence, and I think that the kind of the big tech, yeah, I guess investor class, has a lot of influence. And there's a big push to for the federal government to say, hey, states are not allowed to regulate AI because we can't have this sort of patchwork regulation and really have like a functioning market. We need the federal government to really set the terms of the interstate market, because I mean there's so many things that kind of get derailed or controlled by one or two specific states that take a heavy-handed regulation approach
Mm,
to things. Like I've had clients, for example, that have had California regulations
yeah,
dictate basically their national policy on how they handle making their products. And I think I think the current administration's attitude is that we don't want to go down that road. We want to have a uniform, much more laissez-faire approach to AI regulation.
yeah. I mean, it does make it really hard, and I know, in a previous, position when I was chief research officer at G2, one of the that this was a when the privacy regulations were like a big discussion point and GDPR was coming in,
Yeah.
and California enacted CCPA, and that was actually a big concern for us because we had to regulate in the US based on a state versus the national law, when it would have made a lot more sense and would have certainly made it easier from our perspective to work under a framework like GDPR, because it's much broader
Right.
and much easier because you weren't dealing with regional differences underneath that.
Yeah. Yeah, but I mean, everybody has sort of different opinions. A lot of people, like like sort of the heavier handed regulation that California
Yeah.
tends to try to impose on different things. I mean, it's many different types of things. Like they regulate the types of like chemicals that can be in certain products, and
Yeah.
I mean, there's just all kinds of stuff that they do that is not present in any other state regulatory framework.
Mhm. Yeah, I know even from a automobile perspective, there were a lot
Yeah,
of, discussion around that over the last year or so,
yeah,
yeah. Um, well, a lot of my clients are working on, AI products and they use them in their workflows, I mean, especially for coding, right? What are what are the top, IP related pitfalls that they should be aware of and they should try to avoid? And then are there proactive things they can do that, they should be thinking about as they go through that process of developing those, applications or other IP?
yeah. So from the proactive side, AI enabled software is conceivably patentable. It's difficult to get a software patent. You got to know what you're
Mhm.
doing, but it is possible to protect AI enabled inventions. I have a lot of clients that are doing AI for whatever their vertical is, and
Right.
we're in the process of trying to protect those with patents. So that's something proactive. In terms of like watching out for things, like I said, with the New York Times lawsuit, these AI models will produce almost exact copies of copyrighted works. So
Right.
one thing I help clients with is sort of like a freedom to operate, clearance search on things. If there's any concern around, hey, do we have the right to use this in view of everybody else's
Mhm.
copyrights, patents, trademarks, whatever, we can do that analysis and kind of give you a clearance to do that, a
Mhm.
legal opinion to be comfortable that you're not infringing on anybody else's rights.
Mhm. I was talking to a friend the other day, and there's this whole vibe coding thing is a big deal, and especially among techie people like me,
Uh,
and he was talking about this. He had this application been using for a while, and there were a couple things around the edges that annoyed him, and so he just sat down and had a coding engine kind of recreate it. Now he didn't have access to the source code, so it didn't copy it, but functionally he recreated this for himself. He wasn't selling it. But I
yeah.
mean, to me, that seems like you could get in a gray area pretty quick if you say, here, make a copy of, make it function like this, and then you started to sell it. I mean, is there risk there, you think?
Yeah, I mean, if what you're copying is protected by a patent, sure. I mean, there's some risk there.
Mm,
Um, the other thing is a lot of people don't know that certain user interfaces, you can actually protect those with something called a design patent.
yeah.
So if somebody has come up with a really unique user interface and has filed a design patent application on that, that's one way to protect user interfaces. So if the like the vibe code app does pretty much like an exact copy of the user interface, that's a potential risk area
Mm,
that maybe a lot of people don't think about. And
yeah.
obviously, if there's a company trademark that's on the user interface, do not use that. Like that. That's just
Yeah,
um,
that seems obvious. That one.
yeah. But I mean, you never know. I mean, I don't know.
Right.
Uh, some people, may not get it. They're just like, oh, this is a cool user interface. But if it includes a trademark anywhere on there, you've got to change that. I mean, that's
Yeah.
just like that is something that successful companies do not take kindly to, is using their trademark.
Yeah, I mean, I would agree with that. I would feel that way too about my own stuff. So that
Yeah,
that makes sense. Yeah. I mean, it's an interesting place to because obviously code and software. I mean, we've been patenting IP, whatever protection there, and so it does seem like there's some grayness around how far can a code generator go, and what do you need to watch out for? So.
yeah. Well, luckily, the database of issued patents is publicly available, so
Yeah.
you can, if there's a company where you're wanting to kind of like vibe code something similar, it's pretty easy to go find whether they have a patent on anything, and if they do, you can kind of even a non-patent attorney could kind of like read through the patent and say, hey,
Mhm.
this looks like something that's concerning, or this is not concerning at all, kind of thing. And then,
Right.
if it's something that looks like it might be close, you can then go to a patent attorney and say, hey, what does this really cover?
Yeah. I
But
mean, I guess from a a protection perspective, or a way to kind of ensure that you're safe as you're going through the development of products these days, that probably the more you're using AI, perhaps that is something you should do before you release the product, or are gone very far down that road. So that makes sense.
Yeah, yeah, we do a lot of that.
Yeah. Yeah, almost, proactive step is to, in fact, make sure that you aren't as you're working through the process, so,
Yeah.
yeah.
Yeah, because especially, the big thing that a legal opinion that you get ahead of time before you launch, if you get a legal opinion that says, "Hey, this is clear, you're not infringing on anybody's property,"
Mm,
um, the big thing that protects against is something called willful infringement. And,
mm,
you know, being accused of infringing somebody's intellectual property is never fun. Like it's not
yeah,
that's never a good situation to be in. But if you are, and you have a legal opinion that you got ahead of time, you're not going to be liable for willful infringement, which is really where like the big damages and attorneys
mm,
fees come. Like it
mm,
can be if you get hit with a willful infringement judgment, that could like threaten the existence of your company.
mhm.
Um, and nobody wants to do that.
No, no. No, I mean, that's a great distinction too, right? I mean, I might do something accidentally, that I didn't understand or didn't know, but if I'm actually making an attempt to copy somebody's, or use somebody's intellectual property, that's a completely different level of risk.
Right.
Mm. Well, so let's talk about the future a little bit, because I'm curious about where you see this going. Where AI and IP law, maybe where's that heading over the next few years? I mean, can you help us understand kind of how this is evolving as it goes forward?
Um, as long as the U.S. Patent and Trademark Office takes the attitude that AI is sort of like a helper and is not going to like disqualify protection over IP, then I think it's just going to accelerate innovation. And like one area that we haven't talked about much is drug discovery.
Mm,
There are these protein folding AI models out there, like AlphaFold and things like this, and there are a couple of other ones too that are able to predict how a protein is going to behave based solely on the like amino acid sequence. And like drug discovery, like pharma companies are using these models to really home in on what might be a successful molecule to treat a certain condition, using the computer as like a very fine cut before they go
mm,
into testing it in the lab or in humans or in animals.
mm,
um, and that's an area that's just exploding right now.
mm. Yeah, I mean, I read a lot about developments in that area and how much it can accelerate the development of drugs that we have a great need for, and that it's been years of research perhaps can be, compressed. So,
Yeah,
and
exactly.
yeah.
And I think that I don't know, there's just going to be a lot of IP that comes out of that. And if it's, if it is ever the case that, oh, well, you used an AI model to help you and that's not protectable, then that's going to be a major change.
Mm. I mean, we've hit this a point a few times, and I'm curious because we're talking a little bit about future and policy and that sort of thing. I mean, do you think is that gonna change? I mean, are we at a point where we really need to address this from a policy perspective? This idea that I should be able to integrate the human and the machine into an output that is protected.
Yeah, I mean, I think that if there's human ingenuity involved at any point of the process, that should be protectable.
Mm,
Um, I don't know that I don't know because the that provides an incentive for humans to
right,
innovate, right?
right.
But if the computers if the models start innovating by themselves, without really a whole lot of human input, and the cost of compute is relatively low, I don't know that you need the incentive of IP protection for
Mm,
that, you know?
yeah,
That's kind of like a complex policy question that really needs to be kicked around, but,
yeah,
because humans are finite in some sense, and especially like smart humans who are able to come up with new stuff that's really, really improves mankind. But if you've got, essentially unlimited compute that's coming up with new ideas and at a very, very, very low cost, I just don't know that the cost benefit is there to provide a monopoly on whatever the computer comes
mm,
up with for, pennies or something like that.
right, right.
So, yeah, it's
Hmm.
something to watch going forward for sure.
Yeah, I mean, that's an area that we haven't really talked about, but I mean, you mentioned, drug discovery or R&D in general, and from what I've written about and talked about over the last couple of years, I've really been pushing this idea of human machine collaboration and hybrid workforce kind of approach. But at some point, especially in R&D, does the machine actually provide the output without the human involvement or and I guess they do in some cases already, but and then at that point, do we protect it or can we protect it?
Yeah, I mean, I don't know that I've seen an innovation that was purely conceived by a computer model. I
Yeah,
just, maybe it's out there. I just haven't seen it.
yeah,
So I don't know that we're there yet with AI, but we're on a trajectory where it seems like we might get
yeah,
there to
yeah,
me.
yeah.
So we're just gonna have to see.
Mm. I mean, it's a complex issue, right? Because we're training the language model on the corpus of human knowledge, right? It is human generated knowledge
Hmm.
that it uses as its baseline knowledge. But then I wonder at some point if we're training the language model on outputs of other language models, is
Yeah.
that is that human knowledge anymore? I don't know.
Yeah, yeah. I mean, it completely goes outside the framework that we've used for the last, whatever, 200 years in this country, 250 years. So, um, it's going to be heavily debated, and we'll just have to see where it lands. But I personally am a pretty hardcore libertarian, so I'm like a free market kind of libertarian guy, which is, I guess, it's one reason why I enjoy defending people who are accused of infringement, because I kind of want everybody to be able to do pretty much what they want to do, without hurting other people. But yeah, that's kind of my own attitude towards it.
Mm. Yeah, I mean, this is an exciting time, and I guess we we talk about it a lot about job security. I mean, I guess that's good job security for you as it
Yeah.
gets more complex.
Oh yeah. Every time the law is in flux, that's great for lawyers because
Nice.
we get to we get to be involved in arguing and interpreting, and and when there are no clear answers, that's when the lawyers are highly needed.
Yeah, and we're certainly in a place where there are not a lot of clear answers.
That's
That's for
right.
sure. So James, really enjoyed the conversation and definitely a great follow up to the other episode that I did. So this I think is really helpful to the audience. I just at the end of the show, I always like to ask, can you recommend somebody, an author, podcaster, book, something that you think would be a great resource for the audience to check out in it, in this subject area, but it could just be life in general if you want to.
Yeah, I would never recommend like a lawyer podcast because lawyers are just really usually boring. But I mean, yeah, I'm sure your audience probably knows this, but I love the All In Pod, with
Mhm.
Sachs whenever he's there, and yeah, and all those other guys. I think those guys have a really good handle on where AI is going,
Yeah.
and I get a lot of value of listening to them and where they think tech is going in the AI space. So I never miss an episode of All In. I'm sure, again, like, sorry, I know your audience probably already listens to those guys, but it's another vote in favor here.
Yeah, no, I agree. I think it's always great information and politics aside, just from the standpoint of tech, it's a very interesting conversation always. So yeah,
Yep.
great recommendation. Thanks a lot. And James, really, I appreciate you joining today. Thanks a lot, and really appreciate all the information that you shared.
Well, thanks for having me, Michael. It was fun.
And that's the show for this week. Thank you all for joining us. Remember to like, share, and subscribe to the show. If you enjoy the show, please leave us a review to help others find us. For more research on AI and other software, check out arianresearch.com. If you're an expert in AI, generative AI, or business automation, either as a provider or an end user, email your information to disambiguation@arianresearch.com. Don't forget to join us next week. Disambiguation is an Arian Research production. I'm Michael Fawcett, and this is the Disambiguation Podcast.